From boardrooms to break rooms. If it's business, it matters.
Thank you for joining us on another episode of Business Matters, where we discuss matters of importance to businesses. I am your guest host, Rebekah Hinds, and today we'll be discussing the disciplinary trap, how employers get it wrong. The tables have turned today, and she is on the other side as our guest on Business Matters. Joining me today, as I serve as guest host, is Patricia White, founder and chief executive officer of Global HR and IR Solutions. Pat is a seasoned HR and industrial relations professional with over 2 decades of experience spanning the private sector, academia, and human capital development. Immediately preceding founding GHIS, Pat has served as manager of employment relations at the Barbados Employers Confederation, where she managed the technical unit and led advisory and policy support for employers across Barbados. Her background combines formal training in sociology, psychology, child protection, training and development, human resource management, and international development, industrial relations, and organizational development from institutions including the University of the West Indies, the University of Kent, the University of Manchester, and the International Training Center of the ILO. Pat is recognized for her aptitude in training and development and is an accomplished curriculum designer and facilitator, having developed over 20 professional development programs. She is also recognized for her deep expertise in complex labor matters, workplace investigations, collective bargaining, dispute resolution, conciliation, and organizational strategy. Welcome to the other side, Pat.
Thanks, Rebecca. I'm in the hot seat today.
Yes, you are. All right, to get things started, today we are discussing a very important topic, the disciplinary process. Let us start with you outlining why a structured disciplinary process is essential for businesses operating in Barbados, especially under the Employment Rights Act.
All right, so as you know, the Employment Rights Act was enacted in 2012, and coming out of that were a set of procedures that employers must follow, contained within the fourth schedule. And these procedures are related to how disciplinary matters are to be initiated in an organization. So essentially, because of all of the things embedded within that fourth schedule, it is important to ensure that employers follow that so that they ensure that they're within the realms of the law and not making disciplinary decisions based on ego, because we know a lot of times people make those decisions based on ego and frustration, and so that they are grounded in procedures and grounded in evidence and fact, based on facts, right? That is the best way in which we can ensure that the process is sound and it can face the scrutiny of the Employment Rights Tribunal and any external parties looking on.
Okay, very good intro. So, HR practitioners sometimes have difficulty getting employers or the rest of leadership to understand why we belabor following specific steps or processes. When considering disciplinary action against an employee, how would you summarize the key rights and protections that the ERA gives to an employee during the disciplinary process?
So again, back to the fourth schedule that I mentioned. Within that fourth schedule is embedded certain rights. These include the right to have the disciplinary charges, for want of a better term, or the allegations outlined in writing, so that the person has the right to know what you are claiming that they've done. They have the right to representation. This is one that people must make sure that they include in there. There's also the right to a fair hearing, the right to an appeal. So not only do they have the right to the hearing, to be heard and have that hearing, but they also need to have the right to appeal whatever disciplinary decision that comes out of that disciplinary hearing and so on.
Okay. So can you explain for me how the principles of natural justice are embedded within the force schedule of the ERA?
So the principles of natural justice are embedded within the force schedule because what it does is it operationalizes the legislation. It operationalizes natural justice. That force schedule operationalizes that. It sets out a certain set of procedures. That same outlining the process in writing, outlining the allegations in writing, outlining the fact that they must have representation. You must afford them the right to representation. If they're not going to have representation, it has to be the employee's choice. But employers are supposed to observe that entire ethos of having the right to representation, and it must be embedded in the letter that they give the employees, inviting them to that hearing. It also is embedded in that with the same right to appeal. The person, if you have a disciplinary decision that is made, it is not set in stone at that point. What should happen is that the person should have the right to appeal that decision, and it should follow a smooth and seamless process. That appeal process should be smooth and seamless with somebody who is different to the person who decided the outcome, who heard the first case and who decided the outcome. So essentially, that is how you try to ensure that natural justice is observed through that process.
Okay, so I think you touched on it just a bit just now, but when some managers hear natural justice, they may not fully understand it, or they may go straight to thinking the course of law, right? Can you break down the concepts of the right to be heard and the right to a fair and impartial decision maker?
Right. So let me deal with right to be heard first. You may think that an employee has done something. And I know years before we had the ERA, an employer could say, okay, I believe you did XYZ, Rebekah. This is it. You're terminated. Or they could say, I believe you did something, Rebekah. So here, I'm placing a warning on your file. What the ERA did is that it embedded certain procedures that you must follow. And out of that is the right to be heard. So you would find that in part A, it talks about how you outline the charges against the employee, the allegations, and then you invite them to a disciplinary hearing that allows them to not only know what is being said against them, but to also respond. It gives them a chance to respond to those allegations. So it's not just a manager or an employer making a wholesale decision to discipline the person without any hearing being had. But what it does is that it allows the person to come and respond to those charges. Say whether or not I did it. They can say I probably did it, but it was under these circumstances, and things are contextual, right? When you have the evidence and so on, then they're able to respond to say whether or not they did it, or what were the circumstances surrounding whatever action they're accused of doing. And then the right to, you said a fair hearing, right?
To have an impartial decision.
Impartial. So yeah, same fair hearing tied up in it. So essentially, the person who is determining the outcome of that case should not have a horse in the race, for want of a better term. So they should not be so invested in the outcome that they're leaning towards a particular side. What their decision should be based on coming out of that hearing is the evidence presented before them, right? The evidence submissions, and then the testimonies of both the accused person and of any witnesses that may come. So essentially, when they're coming to that hearing and they're hearing what the employee is saying, it should be on a clean, fresh slate, hearing just what is presented there, reviewing the evidence, reviewing whatever the witnesses have said, and then making a determination based on that, and not some preconceived notion or how they feel personally about the person or about the situation.
Okay.
Right?
All right. So, how does the principle of proportionality guide an employer in choosing the appropriate disciplinary sanction?
Right. So that's a very good question, because it leads back to a recent judgment with Massey, right? What that really means is that, in a nutshell, the punishment should fit the crime. It should be a case where if the allegations against the employee is one that is not severe, then the response should not be severe. Whatever the employee does, it should be the response that the employer gives should match that. So let me give you a classic example. if an employee has an attendance issue and is, for the first time that they have that attendance issue, the first response should not be termination. That would be seen as heavy-handed, right? Or let's say, for example, the person has a performance challenge. That's the first instance of them having that performance challenge. The response should not be termination. It should not be heavy-handed. And it goes back again to what the fourth schedule talks about. The fourth schedule talks about progressiveness when you're treating to disciplinary infractions. So a person should not necessarily be dismissed on the first infringement unless it is gross misconduct, right? They should be given the chance to understand what they've done and given the chance to repair and to engage in corrective action, right? That should be the first response. It shouldn't be a heavy-handed approach. So essentially, proportionality speaks to that concept.
Okay. So if, in other words, for instance, if I have an attendance issue and you have an attendance issue as well, the outcome should match both of us having the same issue. The outcome should be the same for both of us.
If circumstances are if circumstances are the same across the board.
Yes.
So I want people to recognize that every case every case turns on its own facts, right? So we may think that the two cases are exactly alike, but unless you are in the thick of it, you may not know that, right? You cannot with certainty say that. However, in general terms, if all two things are aligned in the same way, then yes, the response should really be the same. If there are differences, and sometimes they really are, then you may see a different response. So I just want people to bear in mind that while you try to align the responses, most of the times, each case stands on its own facts. And we cannot forget that concept either. Right?
Yeah. I have seen many instances where leaders or employers argue that an employee has engaged in gross misconduct and should be terminated on the spot. What would you say is critical for employers to understand when attempting to categorize a behavior as gross misconduct? I'll pause there because it's a two-frame question.
No problem. So what you're asking me what they should consider, right?
Yeah.
What I don't want them to think is that they can just, in an ad hoc manner, categorize everything as gross misconduct or categorize something as gross misconduct so that it justifies their need to summarily dismiss a person. And that's what I've seen a trend of that. If they want to summarily dismiss a person, they all of a sudden say it's gross misconduct. But gross misconduct really is defined as behavior that strikes at the heart of the relationship. The behavior is so irreparable. The behavior is so egregious that the relationship is really irreparable, right? This is a key thing that I want employers to understand. It strikes at the heart of the contract, the employment relationship, and that you can see no way that the relationship will continue. So that is a key thing I want employers to remember and understand before they attempt to categorize something as gross misconduct.
Okay, so can you tell me what are some examples of behaviors that at face value could potentially be categorized as gross misconduct?
So without having all the facts of a case, I would say prima facie, you would say things like theft, fraud, threats of violence, or actual violence. These are some pretty easy ones that you can categorized as gross misconduct, but obviously it is aligned with having full context of whatever the case is about, right? And knowing what is happening, all the circumstances of the case. But those are a few examples that you tend to find being categorized as gross misconduct.
Thank you so much, Patricia. I'll pause for a brief moment as we take a word from our sponsors.
Come on, Jake. One eyeball. When I no go peep, when I can be worse. Peeping. Everybody peeping, them like too much peeping. Everybody peeping. I give them one eyeball, you know got to peep. You know got to peep, you know got to peep. I give them one eyeball, you know got to peep. And when you're done it.
Welcome back. So let us delve a little bit into the investigation process. Can you tell me what a thorough and fair investigation process looks like?
Yes. First of all, I want to say that an investigation process is critical. In most instances, before you move to say you're going to discipline someone, you should ensure that you've conducted a fair and impartial investigation, right? The first thing, it should be timely, right? You don't want to stretch out an investigation a never-ending time frame that you start to lose focus on what it's really about. So it should be timely. It should also be structured. So first of all, employers should ensure that they select an investigator that is impartial, again, has no stake in the matter. I would say always try to go for independent third party if you can, but where that is not possible, choose someone in the organization who has no stake in the race, and then have them, or they should have, a clear investigative plan outlined where they have it focused on the evidence that needs to be gathered, who they need to question, who they need to interview, so that they can gather whatever information that they need. And the timeliness is very important, especially if the employee is going to be suspended with pay, because you want to make sure that that suspension with pay is not stretched out to a period that is too long. Because what it does is that it kind of fractures the relationship with the person sitting there on suspension for a long period. It can also make the relationship untenable if it stretches too long. So these are some of the things that employers should consider when they're thinking about an investigation and so on. And then a report, obviously, we would want to ensure that you have a well-structured and clear report that gives the essence of the findings from that investigation submitted to the parties, that the necessary parties, and then obviously the findings should be submitted to the employee if they're going to be brought up on the charges and so on, the disciplinary charges. You want to submit those findings to that employee as well.
Okay. So can you tell me, why should employers avoid making a predetermined decision before a disciplinary hearing?
If employers come into a hearing or with a already predetermined outcome, then essentially the hearing is a sham, right? The whole purpose of the hearing is for employees to respond to whatever allegations you've outlined to them. And remember, I said earlier that where natural justice is concerned, they have the right to respond to any allegations against them. You cannot observe natural justice if you've already determined what the outcome is to be. You should be coming into that hearing ready to hear, listen, because it may surprise you. You may hear them say something that you did not think of, or shed light on something that puts that entire thing into different contexts. You may see now, oh, but this is what I thought the employee was doing, but in reality, this is now, they've brought evidence or they've brought forth a submission that shows now that it wasn't really what we thought it was. So you shouldn't come with a preconceived notion. You should come to that hearing prepared to listen and hear what is going on, and then make your determination after that.
Okay.
It is just fair to the employee.
How long is a reasonable period of time to conduct an investigation before moving to a disciplinary hearing?
So you see, that's not a question I can really say is maybe a day, 2 weeks, 4 weeks. It is all contextual. It depends on the matter that's being investigated. It depends on the allegation. You may have something that is at face value, you can move forward quickly. The investigation can move quickly, and you determine whether or not it really should go now to a disciplinary hearing. There's some things like that. There are other things that are more complex, other matters that are more complex that could call for you to have to, the investigation may go on much longer, because you may have a lot of people you have to, a lot of witnesses, potential witnesses that you may have to interview. You may have to call the employee who's under investigative review back more than once to clarify some things and so on. So it's all really contextual, and it just depends really on the circumstances being investigated, right?
Can you explain for me why employees must receive advance notice of the allegations and supporting documents before the hearing?
Right. So this goes again back to the whole principle of natural justice. If they are to be given the right to respond, how can you respond to something if you are not given the allegations set out, to you, and if you are not given those in advance? And the act really says it must be in writing. I shouldn't be giving it to you word of mouth and then calling you to a hearing. This should be settled in writing because it gives the person time to reflect on what you're saying about them, and it also gives them a document that they can take to their representative and have them prepare their case and be ready to come to respond appropriately to the allegations against them. It is just simple. It's just basically that you need to ensure you follow the law and need to ensure that the person has a fair chance to respond to whatever you're alleging against them.
Okay. There's still some confusion about the difference between a representative and a witness. Can you clarify the difference between the two?
Right. So a representative is the person who accompanies the employee to a disciplinary hearing and can help them sum up the case. They can help them put up the case. They can help them explain certain things that the employee may not understand. Some may even want to ensure that the process is being followed fairly. A witness is a person who comes to give an account of something they have seen that is related to the matter at hand. So they're coming to give a testimony at the disciplinary hearing. They may give a witness statement that gives an account of what they've seen or heard. And please, it shouldn't be secondhand information. It should be what they have seen and heard and what they know for a fact about the matters at hand. So that's the difference between the two. And you are correct. I've seen where even after all this time, people still are having challenges understanding the difference between the two roles.
Okay. Along with the difference, I've also seen persons bring in witnesses from the beginning of the meeting, and they have input towards the whole meeting. Is that something that you advise?
No.
Should a witness be out there from the start of the meeting?
Only way they should be at the start of the meeting is if their part is for the full meeting. But if they are coming to give a testimony for a particular thing that they have seen, that is what they come to the hearing at that point to do, and then they go from that hearing. Because you don't want it to be a case where they're influenced, their testimonies are influenced and so on. They should come at the part where they're giving their testimony, and then they can go on.
Okay. So what are some expectations for representatives who attend hearings? We know some of them come and they behave very badly. But what is the expectations, guidelines, layouts for representatives when they attend these meetings?
Well, I will tell you, for me, when I chair meetings, when I chair hearings, or when I advise business clients about hearings, I always tell them, and I always for myself set rules of engagement. So I begin my meetings with rules of engagement. This is how this engagement will go. It will be a respectful engagement. All sides will obtain. We'll ventilate the issues, but the disrespect will not be allowed. Representatives are to come to the meetings, like I said, help the employees sum up the case. I allow them to also, if they want to speak on behalf of the employee, I allow that. But what I will not allow them to do is to be loud and disrespectful, cantankerous in the meetings, because what that does is it sidelines and sidetracks the meeting. You don't get the issues ventilated. You don't get to have a proper discussion about what has happened. You don't get to hear properly from the employee, let them explain themselves. And sometimes they block the employer's side from giving their account of the matter. And that's not how it should, that's not how the meeting should go. So if I come across that, I haven't come across that in years, but if I come across that, I tend to give a warning about it. I talk to the representative and let them know, you know, how it's disruptive to the process. It does not allow, and it is disruptive to the person they're representing, because the person is not being able to give their side properly so that the employer can make a proper decision based on the information they have. So I explain that, and I give them a warning about it. If it continues, then and it makes the meeting untenable, then the meeting would have to be adjourned, because we can't get to the bottom of the matter and resolve the matter if they're behaving in that manner.
Yeah, I agree. All right. There have been allegations of leaders, because of not following the process as it ought to be followed, have inadvertently not facilitated employees' rights to representation. What issues can arise when employers subtly discourage representation?
Well, in a nutshell, they breach the Employment Rights Act, the fourth schedule, because, as I said earlier, they have the right to representation. And the only way that the representation is not observed is if the employee insists that they don't want representation. The lack of representation should not come from the employer stopping the employee from having representation? That's a very good question. I know of a previous experience with an organization. How they would do it is that, yes, they would give the employee an invitation letter to the hearing. But what that invitation letter lacked is a date and time for the meeting. So they would have the right to representation outlined in the letter, but it lacked the date and time for the meeting. And what they were doing is that when the manager decided that, okay, I have the space to do this meeting, they would call the person from their station and have the meeting. Now, when I saw that, I said, you're in breach of the act, because if you don't give the time and the date of the meeting in advance, how can they inform the representative of when the meeting and date is? And then when you call them just ad hoc to the meeting, they have not had the chance to inform the representative that they can come and attend the meeting. So, in essence, when you present the invitation letter, it has to have it contained in there the date and time, that right to representation, and the employer should facilitate the representative being at that meeting once the employee says that they have representation, right?
Okay.
If you don't do that, you're in breach of the act.
Okay, what about employees who come to the meeting and they don't have a representative? They've chosen not to opt to have a representative on the day, but then later on they change their mind or say, well, I didn't know. How do we clarify at the start of a meeting that the employee is aware of their rights?
Well, what I do, for me, when I chair meetings and when I advise clients, I always refer back to that invitation letter. I start it by saying you were issued with XYZ, and in that letter, you were indicated that you had the right to representation. Did you understand this right? And when they respond, I said, okay, and I see you have brought no one. Did you know that you had the right that you could have brought someone to this meeting? They usually say yes. I said, so because you have no one, should I take it to mean that you have decided to waive that right? And they usually say yes, and we proceed. Another fail safe that I tell employers to do is to have a sign-off form. Have a sign-off form that clearly outlines, Rebekah Hinds, have decided to waive my right to representation. I was told about my right to representation and I decided to waive it. That is my other fail safe, because at the end of the day, I don't want you to come back and say that you were not afforded that right. We have it in the letter. I stated at the start, and we also have a sign off.
Okay, documentation is key.
Yes, if it's not right, it didn't happen, right?
Yes, word of mouth can change very quickly.
Yeah, we've seen that. As HR practitioners, we've seen that many times, right?
Yep. You have developed and delivered professional training on ERT rulings and disciplinary processes. Give our viewers a snippet into one ERT case that serves as a cautionary tale for employers where poor processes resulted in a ruling of unfair dismissal.
You're putting me on the spot, Rebekah. There are many. I can easily call to mind Caroline Haynes versus Barbados Beach Club, I think it was. With that case, Ms. Haynes and another employee were engaged in a fracas in the workplace. And the employer, the manager, they called her to a meeting and they terminated her on the spot. So sans an investigation, and they missed out quite a few of the elements within the full schedule. So she was not given right to representation. She was not given right to appeal and all of these things. So essentially what the ERT ruled was that although the company had good grounds to terminate her services, because the handbook clearly outlined that if you fall on the job, you know, the outcome could be termination, they automatically lost because of procedural missteps. They did not follow the procedures set out in the fourth schedule, and essentially because they did not do that, they lost the case. So even when you have good grounds to terminate a person or good grounds for any disciplinary action, if you have not followed those procedures, you have lost the case.
Okay. Thank you, Patricia. Give us 1 minute. We'll have a brief word from our sponsors.
This stunning set was sponsored by Abbott's. You can grab every piece at Swan Street, Sheraton, and Welch's, or shop at your convenience at abbots.bb.
Good times, everybody. Good times for all of we. It's time to have some fun. Good times for everyone. Conquer cheese steak. Lots more salted or half them mixed. I'm a nut, fruit or cashew. Barbecue steak, ain't natural rings too. Toffee popcorn, fruity popcorn, caramel popcorn. Choose any popcorn. Flavor for this good. party. Good times for all of we. It's time to have some fun. Good times for everyone. Good times anytime, every time. The good time snacks. Whoa. Plug in.
Welcome back. What trends do you see in ERT rulings that suggest employers continue to make the same procedural mistakes that we were just discussing?
Well, the constant losses at the ERT, as you know, employers are the ones who lost the most who lose the most at the ERT. I think the employers have won about 3 or 4 cases. I think I stand to be corrected on the amount, but we lose most of the cases at the ERT, and we lose not because they may not have good grounds again to terminate the person or good grounds to take a certain decision, but it's the process that they've taken to get to that decision. The process they've taken to arrive at the decision is flawed, and if the process is flawed, the outcome too is flawed. So that's the trend that we're still seeing.
So leaning in more to that decision that you're speaking of, when is it important for an employer to consider an employee's length of service, performance history, and mitigating circumstances before issuing discipline, and when can those things be potentially disregarded?
So in most circumstances, all of those things should be considered, right? Again, every case stands on its own facts, and is really contextual, right? It depends on what a person has done. But however, again, in the first, people should not be terminated, or you should not come down with a heavy hand where discipline is concerned in the first instances of a person engaging in misconduct, right? Or in a breach, I should say, in a breach. When they can be discarded is with gross misconduct. Plain and simple. If the person has engaged in gross misconduct, it may be so egregious in nature that all of those things before may not be relevant. You have breached my trust, you've engaged in fraud, or you've engaged in theft. Our relationship has broken down. I cannot continue with you because I don't know what you will do next. I have to be peeping over my shoulder all the time. So therefore, this relationship is untenable. And that is when, those are the instances when you could disregard that. But in almost every other instance, you should take those things that you mentioned into account, right? Because again, we're talking about progressiveness. Has Rebekah done things in the past before? No, she was a model employee before, and all she's done really is maybe something with performance, which is not particularly egregious. So I need to work with her. I need to consider all she's done in the past before that was good, and not be heavy-handed in my decision.
Okay. All right. So we've covered the invitation. We've covered gross misconduct. We've covered the decision making. We've covered the outcome. Let's talk about the appeal process. What should an appeal process look like, and why must it be chaired by someone independent from the original decision?
Right. So when you talk about the independence, we're talking about separation of roles, which again is extremely critical for natural justice, right? Essentially, if I have chaired a disciplinary hearing and I'm determining the outcome, I should not be the person chairing that appeal and determining the outcome. What prevents me from not ruling in my favor again? I made that original determination. What is to stop me from making the same decision because that is what I want it to be? So again, if we're talking about natural justice and we're talking about a right to a fair hearing, removing bias and so on, an independent person who had nothing to do with the prior, had nothing to do with the investigation, had nothing to do with the original disciplinary hearing and that original decision should be the person who's now hearing this fresh ears, fresh eyes, reviewing the case in fresh terms, reviewing the evidence in fresh terms to determine whether or not it was fair. A fair process was followed, a fair decision was had, and again, it depends on the points of appeal, right? They follow those points of appeal and determine whether or not that the original decision is upheld or whether they throw that out and it maybe issue something else or move it altogether. So again, it comes back to really following the principles of natural justice and making sure that it is fair to the person who is subjected to it.
Okay. So we've talked in length about having separate persons in terms of doing the investigation,
separation of roles,
conducting the chairing the meeting, and know the appeal process. So I don't want to miss out anyone. How can businesses which may not have large HR teams still ensure compliance with the ERA when managing disciplinary matters?
So I would say, with regards to that, they should set up. I always advise those small companies to set up your process beforehand. If you have an established process beforehand, it makes it easier to follow. So have your templates, like an invitation to disciplinary hearing template that you just fill in with the evidence and the different things into that. So it starts with templates. It starts with how you have the process outlined and so on. And if you know that you don't have a lot of staff that you can have this manager do the hearing and this manager XYZ, what you do then is that you can bring in an independent person outside, an external party who can do that for you, right? So you maybe can handle the first stage of it, and then if you want to ensure that you have that right to appeal, afford the person a right to an independent appeal, you bring in an external party to do it for you, or you can bring in an external party to do the entire thing for you, right? So that you separate the roles and you ensure that you stay within the confines of the law, right?
Okay. So 3 things that have really stood out for me in this chat, Patricia, is separation, documentation, and fairness. As we close, what are the 3 most critical reminders you believe every employer should keep in mind before initiating disciplinary action against an employee?
So I would say, firstly, to take ego and frustration out of it. I want to really hone in on that, because I know a lot of people, they make decisions based on ego or based on frustration. And when you do that, you're prone to mistakes. Secondly, I would talk about, again, having an established process so that you keep doing what you're familiar with. So if you have that established process and you have those documents already, the templates, it is much easier that you wouldn't, you're more likely to not slip up, engage in a misstep. And then I would say, thirdly, follow a sound investigative process and ensure that you make decisions based on the evidence and the context of the case before you, and not on the person before you necessarily, and not on your personal feelings, right? Those are 3 things that I would say would be good pieces of information, good key takeaways for employers.
Thank you so much, Patricia. As we bring today's conversation to a close, it is clear that discipline is not simply about enforcing rules. It is about fairness, structure, and respect for due processes. When employers shortcut investigations, misunderstand gross misconduct, ignore the principles of natural justice, or fail to separate roles in the process, they expose themselves to serious legal, financial, and reputational risks. A properly followed disciplinary process protects employees' rights, but it also protects businesses from avoidable findings of unfair dismissal before the Employment Rights Tribunal. We hope this episode has reinforced the importance of preparation, objectivity, documentation, and independence at every stage, from investigation to sanction to appeal. Thank you, viewers, for joining us on Business Matters today. Thank you, Pat, for your in-depth discussion on the disciplinary process. Until next time, signing off as guest host, Rebekah Hinds.
From boardrooms to break rooms, if it's business, it matters.